Yes, well, I am Ned Fletcher, but my question is that David Williams? Because sounds like David Williams, but he's come back from Antarctica looking like one of Scott's party. Not recognising David is perhaps an explanation for why he thinks I'm going to talk about my thesis, but in fact I'm going to try to pick up on a few things that we've heard today and maybe a little bit on the thesis at the end, although because it's at the end we might not get there. But because my interest is really in history rather than contemporary law and politics, what I say might resonate a bit more with what we've heard this morning from Bain and Michael rather than so much from John. But John loved the paper and loved the chapter and agree entirely with it for the reasons that David has given. And those of you who haven't had a chance to read the chapter should do so. So my PhD was on the English draft of the Treaty of Waitangi and what it meant to its framers. And I didn't consider the uses that can be made of that history in contemporary political and legal advocacy. And in choosing the topic that I chose and finally finishing it, I'm definitely not trying to promote original intent in contemporary treaty interpretation. I'm a living trees man. Although I tried hard to lose myself in the 10 years between 1835 and 1845, I recognise that my views about where New Zealand is and where it might go was baggage that I brought with me, and I leave for others to judge the extent to which it's distorted the conclusions I've reached. I think it's inevitable and appropriate that historians ask questions of the past that are prompted by the questions of the present and with an eye to the future. As the historian E.H. Carr argued, the writing of history is an unending dialogue between past, present and future, and good history endures because it speaks to the future. Many of you, I know, are involved in working out the place of the treaty in contemporary politics and law, and as I say, that's not my field. But I imagine we can all agree, and John puts this very well in his chapter, that a better understanding of history is the indispensable starting point, even if it's not the end. And I should say that my topic on the treaty is just a small part of the history of the treaty. It's concerned with the understandings in and around 1840 of the British framers of the English draft, and there's 175 years of treaty history since. But even in respect of the 1840 story, my thesis doesn't directly deal with Maori understandings of the Maori text, the understandings of the translators of the English draft into Maori, and the understandings of others who weren't directly engaged in the treaty making. So it's just a very limited part of the story. Despite these limitations, it seems to me that the English draft and its framers' understandings are important, not only if we want to get our history right, but also as the starting point for contemporary legal and political engagement. And that's partly because the English draft came first. If the view is taken that the treaty drafting on the British side was chaotic and resulted in a document that was ambiguous and contradictory, if the view is taken that the treaty was a deceit and a device to pacify, amuse and pacify savages, if the view is taken that the treaty was never intended to be constitutive of the new polity, but was rather a political expediency which was spent once the agreement justified the independent assertion of British sovereignty, If the view is taken that the Maori and English texts of the treaty are irreconcilable, then it's understandable that the treaty may have been seen as an artefact of history rather than the seed of the living tree of the New Zealand Constitution. Instead, its practical impact has depended on mediation through political accommodations such as legislative recognition of its principles. As a result, the text and how it was understood in 1840 have been neglected. The loss of focus on the treaty is not something that's new, and a number of reasons can be conjectured for it. And I've got a number here, but I think I'm just going to mention 3 or 4. Historians in New Zealand may have been put off by prevailing legal views that the treaty had no domestic effect and that discovery and settlement, not cession through the treaty, were the true basis of British sovereignty. Those mid-20th century New Zealand historians who considered the treaty certainly accepted such legal views uncritically, and I think they didn't appreciate the extent to which the prevailing political and legal opinion represented a peculiarly New Zealand enthusiasm for a strand of late 19th and early 20th century opinion on international law, which I think was highly contestable. So New Zealand scholars didn't pick up on the classic 1926 work of M.F. Lindley, which is still good in every respect but for its title. It was called The Acquisition and Government of Backward Territory in International Law, being a treatise on the law and practice relating to colonial expansion. Now that book had been cited by Trevor Williams in one of his essays that David has mentioned in 1940, but our historians didn't pick up on it, and instead they were much more influenced by the writings of someone like N.A. Foden, writing in 1938 with arguments that misunderstood the historic record he draws on. Now, Williams also cited Foden, but it was clear that he saw that Foden was arguing something that was different from Lindley. Another reason for the neglect of the English text, as has been mentioned, of course, is Ruth Ross's influential 1972 essay. And that meant that the English text was eclipsed with recognition that the Maori text is the authoritative one. And I take no issue with that conclusion, it's absolutely right. But a further and less happy consequence was that the English text, treated as self-evident, was taken to contradict the Maori text, locking us into this debate about whether the differences were the result of deliberate mistranslation. In more recent years, much of the historical writing on the treaty has arisen in a litigation context, whether it's courts or the Waitangi Tribunal, and I think the research questions have been shaped by that process. Until the recent Northland inquiry, only a limited attention was given to the English text and its framers' intentions. The tribunal itself has generally treated the two texts as complementary, but in the Northland report, as David has said, followed the Ruth Ross orthodoxy, although some of the historical reports done for the tribunal, in particular that of Samuel Carpenter, who it's great to have here today, had, I think, offered a different path. And finally, maybe explaining the neglect, in the past 20 years, lawyers and legal historians have dominated the field and partly displaced a treaty focus with an independent common law doctrine of Aboriginal title. The conclusion of my thesis is that if attention is paid to the text, its drafting, the framers' backgrounds and intentions, the context of empire and its dealings with Indigenous peoples, and the broader drift of ideas at the time, then it becomes clear that the treaty wasn't ambiguous and contradictory in context, and that the English and Maori texts reconcile. It wasn't a deceit to pacify Maori. While it may not have been without precedent in empire, I think it was, thanks to its principal architect James Stephen, the Under-Secretary of State for the Colonies, if not a new method, then as Trevor Williams said 75 years ago or more, the coherent enlargement of an older and more tentative method of attempting to protect a native race from the inrush of a new and essentially different culture. So after 1,000-odd pages of my thesis, I couldn't come up with a better line to end on than one that Trevor Williams had come up with in 1940. In the handout, which was circulated by email, there's a summary of the thesis, so if you do want to read anything, just read that. Don't bother with the whole thing. And the handout, I set out the principal conclusions of the thesis about the meaning of the English text to its framers, and in brief they are that British intervention in New Zealand in 1840 was to establish government over British sub-settlers for the protection of Maori, that British settlement was to be promoted only to the extent that Maori protection was not compromised, that Maori were recognised as full owners of their lands, whether or not occupied by them according to custom, and that Maori tribal government and custom were to be maintained. British sovereignty was not seen as inconsistent with plurality in government and law. Someone will cut me off, I'm sure, but I thought I'd address only the last of these points about sovereignty, self-government and custom. So first, the conclusion that Maori tribal government and custom were to be maintained. So while the English draft contains no explicit recognition of Maori self-government and custom, and while the preamble refers to the benefits Maori as well as British settlers will obtain from laws and institutions, and while Article 3 is capable of meaning that Maori under the treaty became British subjects, I don't think that that establishes that with sovereignty, British government and laws superseded Maori political organisation and custom. I think instead that the evidence points in the other direction to retention of tribal autonomy and custom. And there are a few bases for that. First, I think there are some textual pointers within the treaty. There are a couple of points here. The first is that the distinction between the chief's authority over tribes and territories in the subscription at the end of the draft and the cession of sovereignty over territories alone in Article 1, I think points to retention of authority over tribes. Second, the reference in the preamble to the Queen's anxiety to protect not only the property but also the just rights of the chiefs and the tribes seems to me something it's difficult to ascribe a meaning to if it's not a reference to custom. Then there's the guarantee of te tino rangatiratanga in the Māori text of the treaty, which inescapably confirmed tribal and chiefly independence. That's a way of saying that, although we've tended to sort of invert this in our scholarship, the Māori translation is itself good evidence of how the English text was understood, which is that there wasn't any inconsistency between ceding sovereignty or kāwanatanga in Article 1 and the guarantee of te tino rangatiratanga in Article 2. That rangatiratanga conveyed the sense of tribal and chiefly independence, and that wasn't problematic for those most intimately involved in making the treaty, is shown by the contemporary or near-contemporary English back translations of the treaty in Māori. So, for example, Henry Williams reported that he had explained the tenor of the treaty to Māori at Waitangi as including the Queen's desire to protect them in their rights as chiefs, and as confirming and guaranteeing their full rights as chiefs. For his part, Busby, when asked by Bishop Broughton in the New South Wales Legislative Council, very similar to this, only a few months after the treaty was signed, Broughton asked him, do Maori have a word for independence? He replied that the closest Maori equivalent was the word rangatiratanga. So this is a man who's been responsible for the English draft, who's sat there with Henry Williams when the Maori text is being explained to Hobson and vets that, makes a couple of corrections, but lets rangatiratanga go, and then tells the New South Wales Legislative Council a couple of months later that that word means independence. Then in a 1859 back translation, Busby rendered Article 2 as guaranteeing full chieftainship, and to the chieftains and nations their dignities, offices and properties. Accordingly, he said there was no inconsistency between the English and Maori texts of the treaty. In addition to the textual pointers within the English draft, the Maori translation and the English back translations, perhaps the most compelling evidence that the treaty was understood to leave intra-tribal government largely undisturbed is found in the explanations given at the treaty signings or recorded in accounts left by witnesses. And in the handout, I set out a number of these, but I'll only discuss one now, which is what Felton Matthew, the colonial surveyor, one of Hobson's 4 officials who came out with him from Sydney in January 1840, recorded in his journal. So this isn't for any other audience. It's just for him and his wife, who he'd left behind. And he said, cue up my bits of paper, so writing of the treaty signing at Waitangi, that the chiefs, in agreeing to cede the sovereignty of the country and in throwing themselves on the protection of the Queen, had nevertheless retained full power over their own people, remaining perfectly independent. He also commented on the stipulations the chiefs had made for the preservation of their liberty and perfect independence, and expressed the expectation that if Maori did not disappear as a result of colonisation, they might, in after centuries, become an enlightened and powerful a nation as we are ourselves. In the thesis and in the handout, I argue from statements like this that the implications of the English text were understood in the same sense as the division between Kāwanatanga and Rangatiratanga in the Maori text. And I relate this to how I think Busby understood the treaty, that it achieved a federal model of government prefigured by the Declaration of Independence. It provided a government, now the British Crown rather than the early Confederation of United Tribes, capable of exercising the federal governmental power necessary for, in the words of the Declaration, the dispensation of justice, the preservation of peace and good order, and the regulation of trade. And you might add, with the treaty, foreign relations to that. And in the handout, I set out a quote from Chief Justice Martin in 1860, which I think really makes the same point much more forcefully than I have. Finally, then, the associated point that British sovereignty was not seen as inconsistent with plurality in government and law. And in the handout, but I make some arguments that this was consistent with the practice of empire. But I'm just going to pass over that and refer instead to some of the post-1840 dispatches from the Colonial Office that confirmed the policy of acceptance of Maori custom. So you get the Colonial Secretary, Lord Stanley, in June 1843. There is no apparent reason why the Aborigines should not be exempted from any responsibility to English law or English courts of justice just as far as respects their relations and dealings with each other. And then Stephen, in December 1843, a memorandum expressing impatience at the legal pedantry that subjection to British sovereignty and subjection to English law are convertible terms. He said there was no reason Maori shouldn't live under their own law, as was the case in Ceylon, India and Canada. And Jacinta started the day by referring to Maori frustration about rights and tikanga ignored, rights that had been guaranteed by the treaty. And in 1846, Stephen had a similar rant. He deprecated interference with Maori custom, writing to Under Secretary Littleton that it had been a great error not to follow the opinion maintained on the first foundation of the colony that native customs should be respected and there should be no attempt to govern Maori in their relations with each other except to prevent war and inhuman practices. So it's really because of views like that and because of the conclusions that I reached, that it won't surprise you that I don't see the treaty as an artefact, but as a living covenant which was and remains constitutive of our polity.